SMU constitutional law professor Dale Carpenter, thank you so much for joining us. So I guess the question really is today, who is the winner of this opinion by the Supreme Court?
Well, I think, of course, the court did not block the enforcement of SB8. So I think it's very hard to say that the abortion providers are the winners in today's opinion. They got a limited win in the sense that their lawsuit can proceed against certain very narrow class of defendants among state officials, but that's much more limited than I think they needed or wanted.
And so the fact that this remains in effect, the Texas Heartbeat Act, is that a victory for, I mean, can the pro-life community say that this is a victory for them?
I think for now they can say that because lawsuits can still be filed against the abortion providers, and therefore abortion providers are still going to face the chilling effect of this law.
And the fact that it's retroactive.
And the fact that it's retroactive. That's right.
And so let me ask you, because there were two cases. We spoke about the case brought by Whole Woman's Health, the abortion providers, but then there was also a case that the United States Department of Justice brought, and that was dismissed, right?
That's right.
And there wasn't much explanation, though.
There was no explanation. This is a case in which the court just issues a one-line notation that it's dismissing the case and offers no explanation. There was only one dissent from that, and that was from Justice Sotomayor.
So in that case, it was an 8-1 decision to dismiss the Department of Justice's claims. And is that because, do you think, because they made it clear in the main opinion written by Justice Gorsuch that this was not about the constitutionality of the Texas Heartbeat Act?
That's right. It's not about the constitutionality of the Texas Heartbeat Act. And frankly, also, a number of the issues that were raised by the Justice Department can now be raised and will be raised in a federal forum by the abortion providers themselves.
And so take us through the case, because what does this mean? Who, under this opinion by the U.S. Supreme Court, who can be sued and who can actually file suit in Texas?
Well, in Texas, of course, anyone can file a lawsuit against an abortion provider if the abortion provider performs such an abortion before 6 weeks. That's the fetal heartbeat bill. The abortion providers had tried to sue a variety of state officials and one private individual in order to block the enforcement of that law and block the filing of these SB8 lawsuits. What happened in the Supreme Court is that when the abortion providers filed what's known as a pre-enforcement action, that is, they filed their lawsuit to block enforcement of the law before there was any enforcement even, the court said you only get to file such an action against a very narrow set of defendants. In this case, that does not include all of the state court clerks around the state of Texas. It does not include the state court judges around the state of Texas. It does not include the state attorney general, Ken Paxton. It also does not include the one private party that was sued by the abortion providers who had potentially was going to be, they thought, be threatening a lawsuit. It only included a very narrow set of, in fact, 4 licensing officials in the state of Texas that have to do with medical licensing and pharmacy licensing.
And so going forward, are the abortion providers or anyone who's going to file suit to challenge the Texas Heartbeat Act, they would only be able to file against these 4 state officials in their capacity as those who are in a licensing enforcement position?
Yeah, so I think the court said a number of things. So first of all, you do have the continued lawsuit against these 4 officials in charge of licensing. So that's going to continue, and I think could be decided fairly quickly by the district court. Second, you have ongoing state court litigation that is attempting to have the Texas law declared unconstitutional in the state court system, and that has been partially successful. And then anytime an abortion provider is actually sued, the abortion provider can raise a defense of unconstitutionality. So the Supreme Court made clear that those constitutional defenses are still available if an abortion provider or other person is sued under SB8. But the only people who can be sued under this so-called pre-enforcement action in federal court is these officials who are in charge of licensing.
So given that, at least when it comes to the federal courts, so that lawsuit will continue. It goes back to, I guess, the judge, the federal judge in Austin, and then what will be left for him to decide?
So the judge presumably will now get the case back, and there will be a hearing held on the constitutionality of the substance of SB8 and whether or not SB8 is actually consistent with existing Supreme Court abortion precedent like Roe versus Wade and Planned Parenthood versus Casey. And then the judge will make a decision about that. And then the judge can enter an order, at least saying that maybe if he holds that it is unconstitutional, as I think most people expect, he could then say, I'm going to block these 4 officials from enforcing their roles in SB8, from acting on their enforcement roles in SB8, so that they can't penalize or withdraw licenses from doctors or others who assist with abortions.
And then from there, it would go back to the Fifth Circuit Court of Appeals, who could then decide to stay the federal district judge's ruling, put that on hold while they review the case. Is that right?
That's exactly right. That could happen. And we could go back up to the Supreme Court in, we'll have to see how long.
And that would be on the constitutional issues.
That would be squarely on the constitutional issues, because the abortion clinics can clearly proceed against those 4 state licensing officials.
And then we yesterday had this case, a state case, I guess, which are the consolidated 14 cases where a judge ruled that it was unconstitutional for Texas, for the Texas Constitution, but the law still remained in effect.
Still remains in effect. There has been no action on an injunction or a block on SB8 yet in the state court.
So today's ruling or today's opinion by the US Supreme Court means that if there are going to be challenges to the enforcement mechanism, these civil lawsuits for the Texas Heartbeat Act, does that mean that any decision on whether they violate the state constitution will have to be done in the state Supreme Court, or in the state courts, and ultimately make its way up through the Texas Supreme Court?
That's right. To the extent that there's a claim that SB8 violates the Texas Constitution, that claim is going to go up through the state courts. I want to hasten to emphasize that abortion providers sought a very broad range of remedy. They wanted to have the law effectively blocked across the board. And the only way to do that was to proceed against these clerks who actually enter the cases on the books. They docket the cases, and maybe against the state court judges from even hearing them. Absent that kind of remedy for the abortion clinics, you just don't get the kind of protection that they were seeking and that they've now been denied, it seems to me, in the United States Supreme Court.
That would have to come in the Texas Supreme Court, do you think?
That's right. If the Texas Supreme Court ultimately decided that at least the enforcement mechanism in SB8 was unconstitutional under the state constitution, then they might be able to block the enforcement of the law.
And my last question to you is the US Supreme Court, as you know, heard the Mississippi case, which is different because the point of viability in that is 15 weeks as opposed to 23 or 24 under Roe versus Wade and Casey, I guess. So do you think that it's possible that once the Supreme Court makes a ruling on the Mississippi case, that would cover the Texas case as well, at least on constitutional grounds?
That's exactly right. This all may be mooted as of next June if the Supreme Court, the United States Supreme Court, actually overrules its precedent in Casey and in Roe versus Wade. Then the heart of the objection to SB8 will then be gone, and SB8 might be unenforceable in other ways, but at least the substance of the law would then be constitutional. Whereas now, under Roe and under Casey, I think almost everyone concedes that SB8 is unconstitutional where it sets that 6-week cutoff point.
And so you're saying basically that if the court, either way, when the court makes a ruling in favor or against the Mississippi case, that will, at least on constitutional grounds, make the decision for the Texas Heartbeat Act. And as far as the enforcement mechanism in SB8, or would SB8 just completely go away?
Well, SB8, so if Roe versus Wade is overruled, and then depending on what the Supreme Court says, SB8 may still be unconstitutional, but more than likely would then be constitutional if the Supreme Court says that a state can prohibit abortion from the moment of conception. And then it depends on what exceptions the Supreme Court demands, and we'd have to look at that decision. But at least in large part, the objections to SB8 would go away when they relate to the substance of abortion rights.
And so if the enforcement mechanism wouldn't matter at that point?
Then the enforcement mechanism would still matter potentially if the state still tried to turn over enforcement to private parties who have no other connection to the litigation whatsoever, and to the extent that SB8 attempts to impose a number of other burdens on these abortion providers by making them, say, retroactively liable for abortions that occurred when they were perfectly legal. So there would still be objections potentially to the enforcement mechanism of SB8.
So in other words, that it would still be up to the Texas Supreme Court to decide whether the Texas Heartbeat Act or SB8 is constitutional in Texas.
That's right. In terms of the enforcement mechanism, that's correct.
All right. SMU constitutional law professor Dale Carpenter, thank you so much for helping us make sense of this complicated opinion today. We appreciate it.
My pleasure.